Recording in progress.
Good evening to everyone, and let me apologize for the late commencement. I was in a board meeting which was also online, running from 5 p.m. until a few minutes after 6. That explains why we are starting now. So tonight, I would like to first of all share with you some thoughts I've gathered from examiners concerning the constitutional law question which came last year. And I mean, of course, we should know that there's not going to be a repetition of the questions or anything like that, but being aware of some of the things that they observed could help us in preparing for anything related to constitutional law, and for that matter. Now, last year, of course, those who started, you notice that it was very sensible to be interested in what was happening at the time. We were in election year. We had like the COVID-19, and it was reasonable to expect whether there could be a question around what the problem was at the time. And of course, there was something like that. So those who pay attention to what was happening were able to make some prediction. But that is not what is important to me. What is important is that we want to find out some of the general concerns as far as the constitutional law question is concerned. At least from some people are saying that they cannot hear. I don't know if that is still the case. Can you confirm if you are hearing me? Let me see. Can you, no, just use the chat. Can you confirm if you're hearing me? All right, okay. Right, thank you. Good. Now, those who say I should unmute, because some of you, you forget yourself and then the noise from your end will be coming into the class. That is why I've muted everyone. But if you want to talk or contribute, you are liberty to do so. You just have to raise up your hand and then I'll release you. So just in case you join us, what we are doing tonight, we would like to focus our revision on constitutional law matters. But before doing that, since last year, there was a constitutional law question. I've been able to talk to some of the people and what their thoughts or impressions were concerning the students' performance. And I'd like to share some of those with you. You just have to listen to me. I don't have anything to show on the screen for you. I don't intend to do that. Just listen to me as we discuss. And we look at the question. Most of the students, we are told, or majority, did not understand the import of the question. A good number of them understood the question as testing their knowledge in a wide range of areas. And this was certainly different or poles far apart from what the question really was. For example, some students, I presume that all of you are familiar with the last question. I think that was question 1 or so. Other one, there were only 2 questions, so one of them. One relating to election difficulty, change of succession of government, and then the COVID-19 and all that. Yeah, so some students had a wrong understanding, and because some of them thought that the question was about the lawmaking processes in Parliament, and for that matter, went ahead to engage in the traditional science of legislation or lawmaking, how a bill how an act of parliament will start as a bill, go through the various stages and all that. And then they walk us through that, or they walk the examiners through that. And that was not what the question was really about. And again, some students also understood the question. Some students also understood the question to be doing something else. And so some understood it as requiring them to debate the reality of various executive instruments, which the president had made under the imposition of what do you call the imposition of measures bill, the legislation which enabled the president to impose measures of restriction so as to contain the crisis. So some thought that the question was about legality of whether executive instruments which were made there were lawful, constitutional, and all that. And some also talked about right to health and that the Constitution is not explicit about the right to health. Some went to learn to talk about all that. And some other students also focus on supremacy of the Constitution. Yeah, so these were some of the excesses or what we didn't actually expect students to look at the question in the way that they did. And another worrying thing is that some students describe the scenario. They just narrated, if you like, the various scenarios thrown out by the hypothetical story or the problem. And they didn't do anything about it. And some students were able to actually see that, okay, talking about what the question was testing, there were a number of possibilities. So some students actually took examiners through all the various possibilities which could happen due to the situation which the question had actually pointed out. I mean, the fact that the term of the government was ending, there was going to be an election, COVID-19, the risks of infection and all that. And then what do? The life of parliament is also coming to an end. So a number of possibilities. So it requires students to do what they call like the creative thinking through the prism of constitutional law. Yeah, so that was what was really required. But it has been recommended that special attention must be paid to correct use of language, correct use of language. And when I was talking about examiners' observation regarding the contract question, I told you about some of these points already. Now, those who were the examiners responsible for the constitutional law also have a similar concern that students don't use language well. And for that matter, students should be penalized or sanctioned for poor grasp of language. And what that means is that when they were marking, if your script was read and the language, they find it difficult for you to be coherent or they didn't understand what you were saying, you were just going to fail. And that was why some reported, some students got 0 over, 30 for that question. And it will surprise you, why would somebody get 0 over 30? So these are some, and again, it is also recommended that students should try and understand what the question is inviting them to, rather than just trying to write anything they remember about, let's say, constitutional, assuming like the question is there. Yeah, so against the backdrop of these generalized observation by the examiners, I would like to do a brief session with you tonight and reminding you about essential aspects of constitutional law. And before moving on, I should like to think that since we have witnessed certain unique situation in the year 2021, even constitutionally speaking, we may, well, nobody is saying that there'll be anything from anywhere, but it will not be out of place if, for example, we were interested in issues like maybe like parliament. If you look at how the selection of a speaker of parliament and also making determination regarding majority, minority, and all the interesting scenarios which the outcome of this year's last year's election presented with respect to parliament in particular. And it will not be out of place if we were interested and then we exercise our mind there. But I'm not saying that there is any guarantee that there's anything like that to come. Now, so let's come back to what is really essential. As far as constitutional law is concerned, we need to remember the basics. And as I have told you in previous classes, some of us, as soon as we mention Ghana School of Law entrance examination, we begin to think that what is expected of us is something different from the basic things. And for that matter, we tend to underrate. To ask for this one is too simple. Nobody will get in an examination. No, that is not the point. So the basic things we learned from constitutional law in the level 100 or level 200, depending upon the particular law faculty that you attended, they are still very much important. Important for not only MCQ, but also important for the written component. Now, there are times that you will get a question, and let's suppose that the question may not be on a specific aspect of constitutional law, but you'll be required to bring your general understanding or maybe a whole lot of areas to actually address the needs of the question. But at the minimum, my suggestion is that as far as the constitutional law is concerned, between now and the time that you write your entrance examination, include the 1992 Constitution as one of the standard things that you read on daily basis. And what I intend to achieve here is that you must have an inside-out knowledge. Of course, you've learned this already, except that you need to just refresh. So you have to appreciate almost everything in this small document, because that is like the minimum before we come to the theoretical aspect of the constitutional law, and there may be a few cases here and there. So if you did not know anything about constitutional law at all, you must know the 1992 Constitution. That one is a must. And when we say know it, it's just a question of, you can read it, on regular basis. Every day. You can just, you start from Article 1. Maybe today, you read about 15 articles or 20 articles. The following day, you do the same thing. Reading 20 articles like in a day is not a lot of work. And let's say most of you have about 200 and let's say 90, but most of the rare articles you need to pay attention about 290. So if you are reading even 30 articles a day, it's not a big deal. If you are reading 30 articles a day, it's not a big deal, meaning that in 10 days, you have read 300 articles, and this is 299. So if you are writing your exams, writing the exams, is it the ending of August or ending of July? Can anybody write it in the chat for us to know? When is the entrance exams? Can you put it in the chat? Okay, so we have a lot of time. 24th August. So 24th August, and today is 4th July. You have what do you call the almost 2 months or 1 month, 3 weeks or whatever. So if in 10 days time you can finish reading the Constitution, it means you can read the Constitution about 3 times before you go for the exams. And as far as the Constitution is concerned, it's not just constitutional law. When we are talking about land law, there are aspects of the Constitution relevant to land law there. So you have to keep that in mind. Even some aspects of tort law, as you will notice, are also based upon the Constitution. So you are not just learning the Constitution just for constitutional law purpose, but it may also be useful in some other areas of the law, and of course, criminal law too. So my advice is that make a strategy. If you haven't done so, you can start tomorrow. That every day you read 30 articles, and this one you are not memorizing, you are just reading it just to create familiarization. So just reading it, no effort to memorize, just look at it and then just read. Just 30 articles is nothing. You can even split it. You do maybe 10 in the morning, you take it like a tablet, maybe 10 at dawn or early in the morning, 10 in the afternoon, 10 in the evening. So 30 articles, you are done. So you do that for every day, 10 days, you have finished the whole of the 1992 Constitution. Then you repeat the cycle again. So by the time you get to 20th August, you notice that as far as constitutional law is concerned, and in any case, they cannot ask constitutional law question, which will not be relevant to the Constitution. Let me tell you that. As far as this your exams is concerned, if there's going to be question on constitutional law, directly or indirectly, you will not lose out if you have spent time learning the Constitution, because it is an essential material. You cannot discuss constitutional law in Ghana without the 1992 Constitution. All the other things are supplementary. This is the primary source and the primary material as far as constitutional law is concerned. And that is why I have come here to remind you and share a strategy with you that you must read this 30 articles a day. For 10 days, you have finished the whole Constitution, and then you repeat the cycle. So in 30 days or 35 days or whatever, you have read this Constitution 3 times. And if you've read this Constitution 3 times, I tell you, there is no way that a constitutional law question will come, or you have a question which requires some knowledge of constitutional law and you'll be found wanting, and you'll be able to write something meaningful, which would get the nod of your examiners. Yeah, so please take that serious. So thank you very much. So having said that, we would like to come back to some basic things of constitutional law. So I'd like to start with some very elementary things which we learned, all of us as students of constitutional law in the first year. Yes, you will be, in those days, we asked constitutional law, we know that the area of the law is an aspect of a public law which governs the establishment of the state and also establishment of the various organs of what? Various organs of the state, the powers and the functions which are endowed with, the relationship between them, and so on and so forth. That is what constitutional law is about. And for that matter, constitutional law is not necessarily just the constitutional document. Of course, the constitutional document is a very important aspect. And for that matter, if we were defining the Constitution, we say that the Constitution is the primary law. The Constitution is the primary law in the sense that it sets up the state as a governance polity. it sets up the various organs, what we call like the arms of government, defines their powers, defines their relationship, the limitations here. And so that is the Constitution. Now that may very well be reduced into a tablet or an instrument like that is fine. But as you know, you go to some jurisdiction, typically we mentioned the UK. UK has one of the most sophisticated law, but we don't have a single document like ours in which we say that this is the Constitution of the UK. It is spread through both written and unwritten means, conventions, various acts of parliament and all that. And until they left the EU, we have the Human Rights Act of 1998, which, as far as the statement of the rights are concerned, perform equivalent role of what we have. So that should tell you that yes, you defining the Constitution, you can talk about the document, but we have to note that the Constitution is bigger than just a document. That is another thing. Yeah, so we have the written and unwritten Constitution, and the very good example of the country which has unwritten constitution, as we know, is the United Kingdom. And if you want to talk about those with the written constitution, United States, Ghana, Nigeria, and so on and so forth. And again, constitution may also be federal as opposed to unitary. So if you say a unitary constitution, that is to say that we have one centralized system of governance, just like Ghana. We have one centralized form. So despite the fact that we have a sort of political devolution in terms of regions and all that, they don't really affect central government power because we have a concentration of power in just one source. So you have like the executive, the legislature, the judiciary. As far as the executive is concerned, we don't have any split. Everything is one. As a legislature too, we don't have a split. Everything is one. So that is a unitary. But if you take like the federal constitution, what is happening is that we have a sharing of power between the center and then what you call like the components, operating units. So you go to Nigeria or the United States of America, you have the federal government and then you have like the state government. In terms of powers, we have allocation of powers between the federal government and then the state government. Certain matters, only the federal government are competent to take care of. Foreign affairs, defense, yeah, those are matters reserved for the federal government. But then when it comes to matters of the economy or even like and all that, some federal countries, it may just be a matter of like the particular state. So the state will have its own executive, legislature, judicial, and so on. Yeah, so just a quick reminder. Again, we also talk about monarchical constitution as opposed to republican constitution. Ghana, we have a republican constitution, meaning that the people freely elect their own government, unlike the situation in maybe like United Kingdom or to some extent Spain, where they have like the monarch, and usually at the moment they will be like the head of state, like the ceremonial government. And again, we also talk about what we call the flexible and then the rigid constitution. And we were often asked, is Ghana's constitution a flexible or rigid constitution? Well, if you say a flexible constitution, that is a constitution which is relatively easier or convenient to amend, to make changes. And oftentimes, the way and manner the changes are required to be made is not very different from how you make like ordinary laws as it were. On the other hand, if you talk about the rigid constitution is not the case that it cannot be amended, but it is extremely difficult and complicated to amend it, and oftentimes it will even require referendum. Just as we have some aspects of our constitution in Ghana. So if you look at Ghana's constitution, you get the sense clearly that there are some aspects. You go to chapter 25, and you get article 289 and then 290, 291. We talk about the entrenched provisions and then the non-entrenched provisions. So if you look at the non-entrenched provisions, it can easily be amended because it's amended like how you pass ordinarily out of parliament. Just have the bill, you do the process in parliament and all that. You don't come back to the electorate. But with respect to the entrenched provision, you cannot just use the law making process in parliament. You need to go back to the electorate at some point in the form of a referendum for them to make a before you can continue with the process. So in your study, just pay attention to chapter 25 so that you also have a sense of maybe if your examiners wanted to be a little bit, if they wanted to dribble you a little bit in terms of maybe like the multiple choice, they could have a question in which maybe they will put certain key words there. And then they will say that all the following are non-entrenched clauses of the Constitution, except. So that means that you must know what the entrenched provisions are and what the non-entrenched provisions are. But usually, for examination purposes, we don't use what we call the not the obvious, or we use like the obvious ones. So at least for the obvious provisions, and you have to know them. Or some of them may not just be the articles, some of them may be like chapters. So look at article chapter 25 of the Constitution, and then if you look at article 289, 290, especially let's say 290, we have listed what the entrenched provisions are. So the entrenched provision, you should know them on your fingertips so that if you got a question like that, let's say in the multiple choice, you'll be able to know your way around it. So let's keep that in mind. Okay, we also need to remind ourselves about the basic ideas of constitutionalism as opposed to constitutional government. But maybe before that, let me as part of like the general introduction that I was doing to constitutional law, let me also say that the constitution of a country may make the country like a dualist country as opposed to a monist country. So that one is also important. When we say dualism or a dualist country, what do we mean? We simply means that it is a country where by becoming a party to international treaty and convention, those treaties and convention will not immediately be binding within that state unless it has been incorporated, it has been domesticated by the parliament of that particular state. So if you take Ghana, for example, Article 75 of our constitution makes Ghana an obvious example of a dualist country. So if we look at Article 75, we are told that where the president or his representative has signed or executed a treaty, it is not binding immediately in Ghana unless it has been ratified by Parliament. And how does Parliament ratifies a treaty which has been signed or executed by the executive? The ratification is done either by act of Parliament or by a resolution of Parliament requiring not more than, not less than one half of all members of Parliament. Yeah, so these are the ways in which treaties which will be signed by the executive may become domesticated. So the takeaway is that Ghana is a dualist country. A proof or an authority for that is Article 75 of the 1992 Constitution. On the other hand, where a country is a monist, that is, it practices monism, what it simply means is that the executive executes or signs a treaty, and it has automatic and immediate effect within the municipal law of that country. And the treaty does not need to go through any other processes before it becomes binding within that country. Yeah, so let us keep these basic things in mind. Before I move on to constitutionalism and constitutional government, I'll pause for 1 minute and take any question or any contribution which any of you may have. If you want to speak, you can put up your hand, or if you just want to put it in the chat, I will look at that. So just 1 minute before we move on. Okay, that is, I haven't seen any hand up. Okay, yes, Galazi, 820, yes, you may speak now. Please go ahead. Yes, I've asked you to unmute yourself, so you can unmute. Galazi, 820, please, yes.
Hello?
Yes, please, go ahead.
Good evening, Doc.
Good evening.
I didn't get your explanation on the constitutional law question last year. If you could highlight it again as far as what it required us to do.
Oh, right.
The constitution, the requirement, how we should have answered it.
Okay, so the question simply required an analysis of the various legal or constitutional scenarios contemplated by the 1992 Constitution. Event Ghana is unable to hold election 7th December 2020. So in discussing the various scenarios, the examiners expected students to briefly mention the constitutional time frame for election, the terms of office of the president, his ministers, the Speaker of Parliament, and members of Parliament. So all these needed to be explored within the context of the various scenarios laid out by the issue the question was referring to. And remember that the context was saying that election could not be held was because of, let's say, the pandemic in which we were, and there was no vaccine and lockdown and all that. So all those things were part of the context. But the focus was not for you to the pandemic. It was not for you to discuss the
Okay.
and so forth, but to discuss if we can have election. Yes, the term of the executive was definitely coming to an end. Term of the legislature was coming to an end. So was there going to be a power vacuum in Ghana? Did the constitution contemplate scenarios like that? Can we get some provisions in the constitution which can enable us to navigate our run around such a conundrum? Yeah, so that was the first of the, as far as what students needed to discuss was. Yeah, and we talk about some observations from some student responses and some students who appeared to have misunderstood the question and were just playing to the gallery, talking about the pandemic, talking about imposition of a Restorations Act and things like that. And so that was what I wanted to say. I don't know if that assists you now.
Yeah, thank you, sir. Thank you.
Let me see the chat. Any other to continue? Yes, but okay, since there's no, okay, let me see the chat. Who? I can't see. No, there's nothing there to see. Okay, Ni. Yeah, Ni, you can have the floor.
Yeah, good evening.
Good evening.
About the monies and the dualists.
Yes.
The Constitution in Article 75 tells us that if Parliament approved by resolution,
Yeah.
when we look at the liberated or liberated case where the Argentineship was seized in Ghana,
yes,
the court ruled that even though Parliament has ratified, that's how I understood it, the state need to enact a law to affirm or to make it part of our laws before that affirmation by Parliament or bad resolution by ratification by Parliament will be accepted.
Okay.
How do you reconcile that?
Well, the fact still remains that Article 75, right? Article 75 is the most important authority regarding the relationship between international law and national law. Now, if you look at Article 75, 2B, that the treaty may be ratified by Parliament using resolution supported by votes of more than one half. As to whether that will be applicable with respect to a particular treaty or not, it will depend upon the type of treaty. I'll give you called the Public Health Act of 2012. If you go and look at that legislation, it's a little bit bulky. You'll notice that so many treaties have been made appendix to that legislation. Although Parliament has passed the act and it has also domesticated certain treaties which we have signed. Now, if the particular treaty that you are talking about, it is said that it is not enough just to simply say that you have resolved for it to be part of the laws of Ghana, and you need to tweak it, tweak it in the sense of working out some other modalities with the provisions workable. Then it will be useful for you to reduce it in the proper legislation and not just a resolution to say that, okay, you approve it. And so I think that is the context which will have to be looked at. So having looked at the particular legislation, which was at the center of the Libertas case, but if that legislation, that treaty or the convention is such that the provisions there cannot just be implemented unless maybe you have tweaked it. You've tweaked it to make it workable within our jurisdiction. Then you need a full-blown act of parliament and not just a resolution. Yeah, I think that is the distinction which can be made like that. Yeah, Ni, I don't know if that assists you. Okay, Ni is gone. Okay, let me see. There's a chat. The background noise is making it difficult to hear it clearly. Oh, really? Background noise from me? No, there's no noise here. Shalina, you still cannot hear me. Shalina? Okay, so let's move on. Then some of you are saying that you cannot hear me. So, but I think others can. Okay, it's better. All right. Okay. Yeah. Yeah. So we come back to constitutionalism as opposed to constitutional law, because I mean constitutional government. So constitutionalism as a concept in constitutional law should always remind us of limited government. So constitutionalism means nothing more than limited government. The fact that you must put restraints on those who wields power, who exercise governmental power. And we know very well, if you go into the political history or political theory, you remember ideas like people who say absolute power corrupts and corrupts absolutely and so on, Montesquieu and all that. So constitutionalism, as Professor Kumado once tell us, is that it's not just about having a document as constitution, and that constitutionalism is going to, okay, no, it's about the values, the ethos, the conviction among the citizenry that those who are being given governmental power should not have it untrammeled, should not have it without any restraints. Because how human beings are. You cannot trust any human being with unrestrained power. So if the liberty of citizenry is not going to be undermined, then there is a need to actually place restraints on those who are endowed with the power of governance. So that is the idea of constitutionality. And for that matter, these restraints may occur, let's say, in one of three main ways. We can have what we call the substantive restraint or substantive constitutionalism, in which you expressly deny certain powers to certain organs or certain functionaries of governance. And so certain matters, certain competences are taken away. The executive cannot do it. Or if they can do it, then it will have to be done in a particular way. Maybe in which case you have what we call the procedural constitutionalism or limitation. So that, yes, you have the power, but if you don't exercise it or use it in a particular way, you have done something which is undermining constitutionalism, or certain competence may be reserved to only certain institutions, and it is only those institutions that will be competent to do those matters. And of course, we can cite a number of like the examples. Either you're talking about substantive constitutionalism, you're talking about institutional constitutionalism, or you're talking about procedural constitutionalism. Now, from your reading, as part of the revision that you'll be doing, notice that I give a typical example. Let's say, can anybody give me an example of substantive constitutionalism? Substantive constitutionalism, anybody? Any example? Yes, D.K. Kardner. Yeah, Kardner. And then
yes, sir. Parliament cannot enact laws that will make Ghana a one-party state.
Good. Article number, Kardner. Yeah, that's correct. Article what? Okay. Yeah, that is true. That is an example. Yes, Parliament has got the power to make laws, legislative power. And yet, that legislative power cannot be exercised to result in a law turning Ghana into one-party state. That is true. Yeah, Francis Tay. Francis?
Hello, sir.
Yes. Yes, go ahead.
Article 107 and the same Article 107 also stipulates that Parliament cannot have any power to make a law that will have retrospective effect.
Okay, that is good. Okay, that is good. I think 1 Samuel 2. Okay, let me. Okay, all right. So Terry has spoken already. 1 Samuel had his hand up. I don't know if, but you should also appreciate that the whole of, let me see from the chat, Article 1, 2. Okay, of course. Okay, so the supremacy, in a sense, is also example. Yeah, Henry Date. Yes, Henry.
Good evening, sir.
Yes.
Would it be correct to say the entrenched provisions of the Constitution falls within the substance of constitutionalism, please?
Yeah, I think generally speaking, yes, it does. Generally speaking, it does. Except that if you want, let's say, a more targeted example, which you can easily relate to, then like you pinpoint and give some of these things that we are being told. Just like maybe like you take the whole of chapter 5, the fundamental human rights and freedoms. They also serve as example of substantive constitutionalism, in the sense that Parliament has power to make laws. Executive, they have the power to govern, judicial and all that, but they cannot exercise their powers in a way which will undermine or which will violate, let's say, that the liberties and the freedoms of the citizenry as enshrined in chapter 5. Yes, Samuel will say. Yes, go ahead.
Article 270.
270, which says that
270.
That in chieftains.
270 subclause 2. Yes. Parliament shall have no power to enact any law which confers on any person or authority to accord or withdraw recognition to or from a chief for any purpose whatsoever.
All right, that is good. Yeah, in terms of examples of substantive constitutionalism, we can get a lot. I know that if we had time and everybody was to give me some, all of you be able to give me example. Oh, I mean that is good. Then we also talk about what you call the institutional constitutionalism or institutional limitation, where certain powers are given to only certain institutions, and only them or only that particular institution can exercise it or can do those things. Yeah, so that one is there. Of course, if it comes to lawmaking, yes, Parliament have been given the power, but we also know about delegated legislation, as we saw last week when we were doing the Ghana legal system revision. But let's say that when it comes to certain powers of the executive or the traditional executive powers, only the executive can exercise it. The same thing applies to traditional law powers, and of course the judiciary as well. And that is why we'll be told that nobody shall have final judicial power except the Supreme Court and so on. So that as far as Ghana is concerned, if you have litigated any matter, when you get to the Supreme Court and the Supreme Court has exhausted the review jurisdiction, of course, we've noted from the 2020 petition decision, the Supreme Court reminding us again that the review jurisdiction is not there to be exercised as another level of what? Appeal. So assuming it could even be applied in a particular case, and once you've exhausted that, then as far as Ghana is concerned, in terms of pronouncement on legality or otherwise of particular subject matter, that will be the end of it. And yes, I'm aware that we have international adjudicating bodies. We have the African Court of Human Rights, we have the ECOWAS Court of Justice, we have the International Court of Justice, we have the, the ICCR and all that. But those international bodies they don't constitute another layer of the Ghana court structure. No. They operate within another legal order, what you call international law. Yeah, so the fact that the ICJ and then the African Court on Human Rights and all that are there does not mean that it brings an end to, or it undermines the constitutional provision that the final judicial power rests in the Supreme Court as it. Of course, we also have procedural constitutionalism, and for procedural constitutionalism, we can cite so many examples. It's the same ideas which we want to talk about when we are discussing separation of powers, especially the checks and balances. Certain procedures must be followed before powers which are be given can properly be exercised, so that you might have been clothed with certain competence, with certain powers or authority to be able to do certain matters, but you are required to follow certain prescribed procedure in doing that. And if you don't follow that procedure, what you have done will not be proper exercise of your power, and it will undermine constitutionalism. And don't forget that, as I said, constitutionalism is trying to place restraint, trying to place some limitation so that you don't abuse or you don't violate liberties of the citizenry. And that is why you might have been given the power all rights, and yet the Constitution will say that exercise in a certain way. Let me give you an example. The president of Ghana has been given the presidential veto, and presidential veto simply means that when Parliament has made law, if you go to Article 106 of the Constitution, of course now, you and I have made a covenant this Sunday. I think, what is today's date? Today is 4th July, 2020. We have a covenant that every day you read 30 articles of the Constitution, meaning that by 10 days, you have read 300, like you have finished the Constitution, and in 30 days, I think in 30 days, you have read the Constitution 3 times. It will be very good medicine before you sit for the entrance examination. So you and I have that covenant. But I just mentioned the president, having the veto. You can veto legislation, but that power is subject to procedural and institutional constitutionalism. Because if we go to Article 106, for example, where Parliament has to assent to a bill, where the President has to assent to a bill which Parliament has passed. If the President refuses to assent to that bill, if we look at Clause 8, for example, 106, the President is required to use his veto in a certain way. If he doesn't follow that procedure, that veto will be invalid, will not be proper exercise of his power. So if you look at let me start from Article 106, Clause 7 and 8. Clause 7, where a bill passed by Parliament is presented to the President for assent, he shall signify within 7 days after the presentation to the Speaker that he assents to the bill, or that he refuses to assent to the bill, unless the bill has been referred by the President to the Council of State under Article 20 of this Constitution. Yeah, so you see how even for the President to say that I won't sign, for the President to say that I won't sign, what he needs to do, what he must follow before that will be properly done. If we look at the Clause 8 again, where the President refuses to assent to a bill, he shall within 14 days after the refusal, A, state in memorandum to the Speaker any specific provision of the bill which in his opinion should be reconsidered by Parliament, including his recommendation for amendments, if any, or B, inform the Speaker that he has referred the bill to Council of State for consideration and comment on Article 90 of the Constitution. So you see how even for presidential veto of legislation, we have procedural constitutionalism or limitation, and then we also have institutional. The president must set out his reasons in a memo, or the president must go to the Council of State for him to convince the Council of State concerning why he thinks that that bill should not be allowed to become a law and all that. So these are just a few examples of what we may call the procedural constitutionalism. And we have like the plethora of like the cases. Remember, when it comes to selection of ministers of states, which provision governs that? Which says that you need a prior approval of Parliament? Anybody? Just put it in the chat. Okay, Ni. Okay, you have Honorable Ni here. Okay, all right. Ni, go ahead.
Article 78 and 79.
Okay, so Ni is on fire. Article 78 and 79 governs the selection of ministers of state, and the fact that you need the prior approval of vote of Parliament. And you remember the old J.H. Mensah case in which the Supreme Court, in which the Supreme Court pronounced upon that. And of course, if you wanted to also cast your minds back to 4 versus the Attorney General. Okay, now related to constitutionalism, now just in case you've just joined us, what I am trying to do is that I want to use the 1 or 2 meetings I'll do on constitutional law for a quick revision of basic concepts. Then the rest of my encounters with you will be like maybe discussing questions in the area of constitutional law and maybe like the past questions or some possible questions. So that is what I'm doing. So I'm just using the opportunity to do a quick brush up so that when we are looking at questions, we have some basic and common understanding. Let's put it that way. Then we also have what we call constitutional government. And constitutional government is not necessarily the same as constitutionalism. Of course, having constitutional government simply means that you have a government which is established by a constitution and a written constitution as such. But that in itself may not guarantee or may not deliver constitutionalism. Okay, before I move, Mr. Boateng has asked a question. Please, do you necessarily need to provide the exact article, or there's a need to know this in the Constitution? Okay, thank you very much. Now, I'm also a company law teacher, so this is the advice I give students when it comes to numbers of legislation and all that. Now, for obvious, if I say obvious, like for the most common provisions, right, or the key provisions, key not in the sense that they're the most important, but like they are the most cited. If you can remember the article, let's say that we are all talking about 106, the mode of exercising legislative power, you know it, okay? So if you remember Article 106, that is good. But if you don't remember it, but you know what is contained in Article 106, tell us what is contained in Article 106. It says that according to the 1992 Constitution, then you tell us what is there. You don't mention Article 106. That is better. But if you knew what is in Article 106, and instead of writing Article 106, you write, let's say, maybe 108 or Article 120. Now, what you have written is correct, but because of the number that you have attached to it, it will make it wrong. Because if you go and look at the Constitution, Article 120, it will not be saying what you have written. But if you just omitted the number and just told us what the Constitution says, you have stated the correct thing. Even if you are not going, assuming, let's assume 5 marks is being awarded. If you've stated Article 106 and you've told us the effect of what is there, are you able to tell us the effect of what is in Article 106, but you're not able to write Article 106? What happens? You get marks, even if you're not going to get the 5, you get, let's say, about 3 or 4, depending upon how you have written it. And I think that is better than trying to go for all the 5 and you end up getting 0 because you put like the wrong number against the correct statement. Okay, so Foster, I think that is the way you should go. Okay, somebody has also asked, can we mention the chapter in case you forget a particular article? Yes. And if you are, see, the chapter, the article, since you are making referencing, if you are 100% sure, state it. If you are not 100% sure, just state the law and then ignore the reference. Because you are better off getting some of the marks than losing everything because you wanted to get everything. You know, sometimes in our quest to get everything, we end up losing everything. But if we were modest, we didn't want to, we wanted to be realistic. Yes, I've learned, but I've forgotten the particular number. But I know the mode of exercising legislative power, or I know what a particular position is, but I don't remember the number. Go ahead and tell us and leave the number. Yeah, I think that is the advice I will give. Okay, then let's move on. Yeah, so I was making the point that constitutional government is not necessarily the same as constitutionalism. Constitutional government means that you have a constitution which sets up the government. That is fine. But that in itself may not necessarily assure constitutionalism. Since you've noted that constitutionalism is really about the community's sense of value, their ethos regarding good governance. And central to that is the recognition that there's a need to place restraint on those who exercise governmental powers. But having a constitutional, just like you go to former Gaddafi's Libya. Libya, they had a constitution, but nobody would say that they had constitutionalism. And not only there, you go to so many, even before the Arab Spring, a lot of North Africa and the Middle East, the various countries have like the constitution, but you wouldn't say that there's a proper constitutionalism. The constitutionalism in the sense of having limitations on wielders of power so that the liberty or freedoms of the citizenry or the government will be safeguarded. So that is the essence of constitutionalism. And that is why having a constitutional government per se may not deliver that. So let us keep that in mind. And even in Ghana, let's go back to our first republic and the famous Ray Akoto case, which you all know very well. Yes, in our first republic, we had what do you call the constitutional government. But if you wanted to test it against proper constitutionalism, you will notice that even the outcome of the Ray Akoto in the then Supreme Court will tell you that what we had in the Fourth Republic did not really meet a strict of constitutionalism. Somebody has asked a question. How is emphasis used, and are we allowed to use it in exams? Okay. All right. That is, I think Mark, Zorelli has asked a question that sometimes when you are reading cases, you will see maybe quotation and divide, italize it, or bolden it. And immediately after that, you see in a parenthesis or bracket, emphasis my. And Mark, Zori would like to know whether in examination, you can also be using that expression, emphasis my. The answer is no. No, because in examination, you don't have the law report in front of you. You don't have the legislation in front of you. And we don't expect you to be a walking encyclopedia to be able to remember and quote verbatim everything exactly as in the law report. And if you are not quoting everything verbatim exactly as in the law report, then you cannot actually underline or highlight it and put against it emphasis mine. And that is why in examination, it's not necessary to do that. And it's just not practical, okay? Right. Any other question before we move on? I'll leave 30 seconds for questions. So before we move on to supremacy of the Constitution, okay. All right, Zoro, that is noted. Samuel.
Okay, sir, good evening.
Good evening.
I want to ask whether constitutionalism and the limitation we are considering here extends to international law. That is whereby we have a notorious and very formidable limitation under international law. Do we consider it in our constitutional jurisprudence?
All right. Okay, thank you very much. Maybe before I come in, I will invite any student who would like to attempt to respond to Samuel's question. Anybody? Samuel's question is that in talking about the limitations under constitutionalism, can we extend it to international law, especially where we have formidable limitations? Maybe, yes. Anybody? Okay, all right. Samuel, nobody is prepared to help you, so I will do that myself. Good. I think if you take constitutionalism, first and foremost, we are talking, and that is why when we were discussing legal system last week, we attempted classification of law. We talk about municipal law, also known as national law or domestic law on one hand, and then we talk about international law on the other hand. So, constitutional law is part of municipal law. Constitutionalism, we are talking about municipal law. So therefore, in looking for examples of limitations, we have to limit ourselves to the national law. And especially so, if we talk about Ghana, because of Article 75 of the Constitution, it complicates the whole thing. If you are to cite international law, because we know that the Article 75, not until the international law has been ratified by Parliament by passing an act or resolution, it does not have automatic binding effect. Yeah, so I think that is how we should look at it. Okay, so this will bring me to the doctrine of the supremacy of the 1992 Constitution. It's a very simple but important doctrine, which we should pay attention to very well. And I will keep reminding you that for the law school entrance examination, as far as constitutional law aspect is concerned, if you did not know anything at all and you not learn anything at all, please know the 1992 Constitution itself. Know the 1992 Constitution itself. That is the minimum. That is the minimum. Good. And of course, if we are to know the 1992 Constitution itself, then we need to appreciate the principle of supremacy of the Constitution. And supremacy of the Constitution, I would say, is a bedrock, is the foundational principle of our constitutional law in Ghana. And not only in Ghana, in all other jurisdictions. if we are talking about law, supremacy of the Constitution is very important. And as we know, if you look at Article 1 of the Constitution, it is quite emphatic that if we are talking about sovereignty of the country called Ghana, it resides in no other person than the people of Ghana. That's the collective, all of us. And for that matter, the powers of government are to be exercised for the welfare and benefit of the people of Ghana. And not just that, that is not enough. It must be done in a manner prescribed by the Constitution, in the manner and within the limits laid down in the Constitution. So that is very important. And related to that is the idea that the Constitution is the first in the hierarchy of legal norms as far as Ghana is concerned. So, and that is why it has the primacy, the supremacy. So if you look at Article 1, Clause 2, we are told that this Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any other, with any provision of this Constitution shall, to the extent of that inconsistency, be void. So for me, my advice to you would be that if you properly understand the doctrine of supremacy of the Constitution, you should be able to gather for yourself 5 or 10 constitutional law cases illustrating supremacy of the Constitution. There are a lot of them. If you want even 50, you can get, but I'm not going to tell. There are a lot of them, but just take 10. Now, by supremacy of the Constitution, we understand that in terms of the origin of the sovereignty of Ghana, it's the people of Ghana. And because it's the people of Ghana, governmental powers are supposed to be exercised in a manner and then the limits laid down in the Constitution for the welfare of the people of Ghana. That is fine. And more importantly, the supremacy of the Constitution requires that the Constitution is the #1 law. It's the primary law. And because it's the primary law, all other laws or any action which is not in conformity, which is not in agreement with the Constitution, the letter and spirit of the Constitution, is to the extent of that inconsistency to be declared null and not void. This is very simple, elementary principle. And there are many cases in which this principle has actually been applied or given effect to. So I think somebody has put something in the chat. Let me see what the person is talking about. Okay, somebody has given his case, Adolfo and the Attorney General. And not only that, there are so many of them. So many of them. Yes, to 4 was the Attorney General. It predated 1992, but that is fine. The deferred December case. So all the cases which have been decided under the Constitution, I would say that about 80% or even all of them, so to speak, are in one way or the other reflection of the doctrine of supremacy of the Constitution. The Lotto case, you remember the Lotto case? Sorry, and not so many, J.H. Mensah, Amidu, Amidu and Kufo and all those things. And you can get, but I would like you to go for those type of cases in which a legislation was struck down as being null and void. Mensima versus Attorney General is also a good case. Now, if you say the NPP versus the Attorney General, there are a lot of them. So it is better to put into brackets the particular type. NPP versus Attorney General, we have the 31st December case, we have the District Chief Executive case, so many of them. So it's better to put into bracket the particular one that we are talking about. Okay. And
Constitution.
And again, in talking about supremacy of the Constitution, you don't just stop at Article 1. Although Article 1 has got the sectional or the article heading, supremacy of the Constitution. But in my view, the doctrine is bigger than just Article 1. Assuming you have been invited to discuss the supremacy of the Constitution as a topic or anything in an exams or the sort, you will not actually, somebody has also the example for against the national. Okay, that is fine. Yeah, there are a lot of them. As for the cases, there are a lot of them. You will not do proper justice if you do not also address the enforcement of the Constitution, because the Article 2 let us realize the rare effect of Article 1. Because the Constitution is supreme and is the primary law of Ghana. That is why Article 2 is saying that if any person is alleging that an enactment, that be any law or anything has been done or omitted to be done, and that is inconsistent with the Constitution, the person is supposed to go to the Supreme Court and seek declaration to that effect. And so that is important. If you're talking about supremacy of the Constitution, you must also discuss the enforcement of the Constitution. You must discuss the enforcement of the Constitution and also discuss of course, the original jurisdiction of the Supreme Court, which is embedded in Article 2, just as I have just mentioned. And another important point, as far as the doctrine of supremacy of Constitution is concerned, is what we call the consequential orders, which are made after the Supreme Court has declared that something is unconstitutional, and for that matter, some remedial measures should be embarked upon, and let's say they are disobeyed. So if you look at Article 2 of the Constitution, Article 2, Clause 3, 4, and 5 coming. Clause 3 makes it clear that where the Supreme Court has directed any person or group of persons, please, where have to mute yourself so that the noise from your end will not come into the class. Thank you. Yeah, so where the Supreme Court has, for example, made declaration that something is unconstitutional and has gone ahead to make what we call consequential certain remedy or to revert that which is considered unconstitutional. Sometimes some lines, some other things. So that if you are not talking, so that you don't get the noise from your end here. Please check your mic.
Connected to wireless.
Yeah, Ni, mute yourself. Okay, I've muted him. All right. Yeah, so I was making the point that where the Supreme Court has prescribed actions which need to be undertaken following declaration by the Supreme Court that something is unconstitutional. Now, everyone is obligated to obey without challenge. And where you do not obey, if you do not obey, it is an offense. So this is what we call like a very special type of offense, what we call the high crime. So when you hear of high crime in Ghana, your mind should not go to any other thing than disobedience of order of the Supreme Court regarding constitutional interpretation and enforcement. So that is a high crime. And if you are the president, since you've committed a high crime, that is the basis for your removal from office. And the same thing applies to the vice president. And all these things are feeding into the idea of supremacy of the Constitution, because the Constitution is the paramount law of the land. Everything must fall in line with the Constitution, so that if something is not aligning properly with the Constitution and you need to make a consequential adjustment in order to do something and you ignore it, that is a very serious offense and is not a light offense. That is why the framers of the Constitution have adopted a new terminology, high crime. And high crime, the punishment for high crime for president is removal from office. And the same thing for vice president, removal from office. And again, if you are not the president, you are not the vice president, for which reason, by committing high crime, you could remove. My line went off. I don't know why. Just a few minutes, we should be finishing. Yeah, so I was making the point that if you are not the president and you or the vice president, you've committed the high crime. And if you look at the Article 1, Clause 5, your punishment include imprisonment for a period not exceeding 10 years, so maximum imprisonment of 10 years, and there's no option of fine. Meaning that if you had all the money in Ghana, you cannot pay that and say that, let me pay money and then I don't go to prison. Now, if you look at South Africa, you know how the court in the South Africa, the commission investigating the corruption against the former president has actually secured some orders for his imprisonment, Zuma. And he is now trying to state by using his ethnic political machination, the Zulu. And now the Constitutional Court of South Africa has accepted to look at his case, whether he has to go to prison or he doesn't have to go to prison, as it were. Yeah, so in Ghana too, ordinary citizen not holding the office of president or the vice president, you can go to prison for 10 years maximum, and you cannot pay money as an alternative option. And again, it also produces what they call the disability, legal disability on you. I'm not talking about physical disability, legal disability, meaning that you will not be eligible for. Yeah, sorry, the internet is misbehaving a little bit, but let's see what we can do and then before we close. So the other point we have to notice that apart from serving maximum prison term of 10 years, you also be disqualified from running for election, or you not be eligible for appointment to any public office for 10 years, starting from the date that you finish serving your prison term. So you have to keep this in mind, because if I'm setting multiple choice question for you, I could, for example, do a question like this. Maybe let's look at this. Let's read this at the whiteboard. I'm just putting something there. So maybe like this is, let's say this is our whiteboard. So there will be a question like this. Kofi was sentenced to 5 years custodial sentence, right? Custodial sentence for high crime. Beginning from 10th April 2021. When can Kofi run or when can Kofi take part in election or accept appointment to public office? So let's suppose that we have a question like this. Kofi was sentenced to 5 years custodial sentence or imprisonment for high crime. Yeah, I was sentenced 5 years imprisonment for crime, beginning from 10th April 2021. When can Kofi take part in election or accept appointment to public office? So, okay, let me see. Try. Okay, so somebody has said 2036. Okay, 2041. Okay, now let's apply the provision. The provision says that if you look at 2 clause 5, B, a person convicted of a high crime of this article shall not be eligible for election or for appointment to any public office for 10 years, beginning with the date of the expiration of the term of imprisonment. So 10th April, so 2021, 22, 23, 24, 25, 26. So meaning that he will finish his term in 10th April 2026. Then you add 10 years to that. So that will give you 2036, isn't it? And then I'll give you 2036 if you're counting well. Good. So let's say that in terms, you have A, 2026, B, 2046, C, 2036, D, 20, sorry, my children were just disturbing, 56. So you will have to know that the correct answer is what? It's C. You can say the correct answer is C. Okay, somebody has brought a question, which is interesting. Yeah, you can say the correct answer is C, where you remember Article 2 clause 5B of the Constitution. Well, Victor Darko has brought up a question that, but in prison terms, don't serve the whole sentence. You serve 2/3 of your sentence. Okay, what do you call the parole and so on? But if you go into prison, that rule is only subject to what we call like the good behavior. It depends upon your conduct in the prison. If you are in prison and you are still misbehaving, I don't think it's not automatic that you get that 1/3 slash off, as it were. But I think you just have to use the raw legal position rather than that sort of the parole type of system they do in the prison. Yes. Yeah. So thank you. Yeah. So I'll just tie up. Okay. Let's say somebody has a question. When that use the normal calendar year. Okay. All right. So that is fine. Well, that is fine. Yeah, Francis, you can mute yourself.
Yes, sir. So please, assuming the question is silent on the terms of imprisonment.
And he just said that
exactly has been sentenced to imprisonment for high crime.
Okay, right. If the question did not specify the number of years, then I will assume the maximum. And the maximum is 10
years. 10
years.
plus 10.
Yes.
All right, sir. In that case, we will have to add on 20 years from the time of conviction.
That is true.
Thank you, sir.
Right. Another question: will the president suffer punishment under Article 2.5 after his removal under Article 2.4? Oh, right. As whether you go to prison. Well, because of the principle of what they call double jeopardy, right? You know, if you go to Article 19 of the Constitution, there's a constitutional principle, what they call against the double jeopardy, meaning that no person shall be penalized twice for the same offense. So if we look at Article 4 and 5, 4 and 5 are not supposed to be read conjunctively. There's nothing, of course, it's not been tested yet, but looking at the structural arrangement of the provision, you don't, okay, a person convicted of a high crime under clause 4 of this article shall, well, there would need to be interpretation, but the most likely interpretation would be that if you're a president and you'll be removed from office, you remove from office, I think that is a punishment enough. And a purposive interpretation may probably work in your favor, that you don't have to go to prison under clause 5A and B. But as I said, if you look at the clause 5, it says a person convicted under clause 4, and then who is convicted under clause 4? The president and non-president. So therefore, it's a question of interpretation, but it's not being interpreted yet by the Supreme Court, because this issue has not come up yet. Nobody has been removed for disobeying. Okay, so one MFA is suggesting that since Article 2.5b, stating that in the case of president and vice president shall constitute a ground, but not an automatic removal, so that may not be the case at all. What will be the other grounds then? Well, if MFI, and if I understand your question well, are you saying that if you read Article 2, clause 4 of the Constitution, it suggests that where the president or the vice president, they have committed high crime by disobeying orders of the Supreme Court in relation to enforcement of the Constitution. It is just a ground that may be used to remove them. So the word is may be used to remove them or consider a ground for the removal, and that is not automatic. I mean, that is true, because don't forget that to remove the president from office, yes, there'll have to be a sort of like a trial in a sense, because even that the president has even disobeyed the orders of the Constitution of the Supreme Court may itself be a disputed matter, which the court will have to go into it, and then Parliament will have to come into it, and the procedure for presidential impeachment and all that may also be invoked, so as to actualize what Article 2, clause 4 is trying to say. But let's take clause 5. If the person has not been removed as a president, because of what we know, you know, if you go to Article 50, Article 57, you know, if you go to Article 57, clause 6, 57, clause 5, and clause 6, that the president shall not, while in office as president, be personally liable to any civil or criminal proceedings in the court. Or C, civil or criminal proceeding may be brought after his late office and all that. So if you read Article 57, clause 5 and 6 together, and you put it in the context of Article 2, clause 5, there's a practical constitutional difficulty. And that is why, yes, that is why it is more likely that unless a person has actually been removed in terms of Article 2, Clause 4, for having committed high crime as president or vice president, the Clause 5 may not be relevant so long as he remains in office as president. Because how can you be president and still be serving a jail term? That is not practical, and that is the wisdom under Article 57, Clause 5 and 6 as well. Yes, David Ajay. David.
Yeah, Doc. Remember January 5th, 2021, when Parliament was swearing members, the Arsenal of MP, James Quayson, defied the order of the High Court and joined his peers to be sworn in. Now, the emphasis on Article 2.5 is on Supreme Court. So you realize that there was a debate, brouhaha, about whether he can join his colleague MPs to be sworn in, because the Cape Coast High Court says you cannot be sworn in until the determination of the case. But they went ahead and was sworn in. So the emphasis here is the Supreme Court. But in the case,
yeah, go ahead. David, go ahead. So, David, are you there?
Hello, Doc.
Yes, continue. Yeah.
So the emphasis here is on the Supreme Court making an order and then you refusing. In the case of James Quayson, it was a Cape Coast High Court that made the order that he cannot be sworn in, but he went ahead to be sworn in. But under this article, it's talking about the Supreme Court. That is the distinction I want to bring about. Thank you.
Okay, all right. Thank you very much, David. Yes, well, in both cases, they are all contempt. However, because the Constitution is the very important law, and the framers would like it to be accorded such respect that it deserves. That is why, where the Supreme Court has made an order concerning enforcement of it, ordinarily speaking, that is a normal contempt of court, contempt of Supreme Court. But it has been escalated to sui generis offense, like a standalone or special type of offense, by giving it even a new name, called a high crime, and prescribing the punishment. Ordinarily speaking, when we are talking about contempt of court not contempt of court as a maybe like the criminal offense under the Criminal Offences Act 29, but contempt of court as a common law offense in relation to the orders of the court, where a court has made an order and you've disobeyed it, or in front of the court you put up a behavior which is disrespectful to the authority of the court. This is contempt, courier, expression, and all that. The court will punish you whatever it considers appropriate. There's no prescribed punishment. And if you remember the constitutional law matter I was involved in, Eliplim, Avemava, and others against the Attorney General, we were making, of course, I mean, that was in relation to the prerogative of mercy. But part of the issue which came up was whether, if you look at Article 19 of the Constitution, which says that nothing is an offense unless it has been defined in written law with punishment for it and all that. Now, for contempt of court is a quasi-crime, for that matter, is an offense. And yet, there's no punishment, and the court will have to award the appropriate sanction or punishment that it considers appropriate. But for this type of contempt of court under Article 2 of the Constitution, Clause 4 and 5, it has been elevated to a stand-alone offense, and that is why we've called that the high crime. Yeah, so yeah, we'll be finishing in a few minutes. The internet is misbehaving and we'll be here for a while. Yeah, so I think that is so. Ajay, thanks for the intervention and then the question. Victor, your hand is up. Okay, Victor. Yeah, Victor, please go ahead. Victor, go ahead.
Hello.
Yes, Victor, go ahead.
Yeah, a brother was just talking about the injunction being placed on the assent of MP. Issue which happened in Cape Coast also during the creation of this current year parliament.
Yes.
He was just trying to say that the man was injected, but yes, he was able to get to parliament. My little understanding of injunction, injunction must be in persona. And in this instance, the MP was not served in person. However, his lawyer was around, but the MP himself was not served. So in this case, how are we going to conclude it?
All right. Yeah, so if the MP was not served, so he didn't have like a personal knowledge of the order. And as you rightly said, it was not an order in rem. An order in persona means that against a particular person and his conscience. And if you breach that, then the court will visit its equitable jurisdiction on you and punish you. Yeah. So if he was not served in person, then as you rightly said, he didn't know about the order at the time that they were being sworn in. And if he got to know after being sworn in, then the order more or less was a spent force because it had defeated the president was sworn in as MP already. So then you have to wait for the substantive case to be gone into as whether what the applicant is saying is a good case or is a bad case. Yeah. So Victor, you are right. Okay, so Francis, let me take Francis and then yes, Francis.
Yes, sir. Sorry, I don't want to sound controversial, but I want to say that what my senior brother have just raised could be a little bit controversial because
yes, go ahead, Francis.
Is the agent, the lawyer is in the know of the injunction. Then in law, you the principal, you are in the know. You are presumed to be in the know. And
well,
we're not serving persona.
Francis, you haven't, because you are just like this class. You've not done maybe civil procedure. I don't want to get very. I don't want to worry on that. But when it comes to orders, right? When it comes to judgment, orders, and things like that, the person who is supposed to comply with it must be served personally. And let's say that you don't serve an injunction on a lawyer, because if you serve it on the lawyer, there's no automaticity that the lawyer is going to get in touch with the client within the shortest possible time so as to communicate the order to him. And it's not the lawyer who's doing a particular activity for which you want to injunct him or her. And that is why, even in practice, right, as a practitioner, if you have an injunction, you don't serve it on the lawyer. You serve it on the, I'm talking about the order of injunction, you serve it on the party. But I would say that it's not necessary for us to spend our limited time for revising the right entrance examination on these matters, which we can debate after you've learned civil procedure in the law school, right? But if you're interested, maybe behind the scene, you can engage me and then you can have some discussion, but it's not really important for this type of exams. Oh, okay. So somebody, one Kofi Prempe, has raised up, if you look at the chart, he's raised up an issue that the cumulative years of 5A and B are 20 years. So how come the answer of yeah, okay, we're ending in just about 2 minutes, so don't worry, my internet is misbehaving. Okay, so just okay, and then the question about the calculation of the example I put there. Yeah, I think the answer is in the chat. I think the person K has actually answered Kofi Prempe. All right, so take it from there. So just before we go, let me remind you that Thursday evening, I think I'll be able to do about 1.5 hours or 2 hours. If you have the time, you can join us. So you put the link on the platforms. So Thursday evening, we will try and do 1.5 to 2 hours. And then Saturday, early in the morning too, I have some groups of students. I'm supposed to be preparing for the entrance examination, but since I'm doing a class for all of you, I'll put their link over there so that if you're able to wake up early, you can join us online and take part. And of course, we still have our usual Sunday one. Yeah, so this week, Thursday evening, Saturday early in the morning, we have our class, and Sunday evening like this. Whose hand is up before I say goodbye to you? Yeah, Ima, is there you want to say something? Okay, where is your hand? Let me see. Ima, your hand must be up so that I'll be able. Okay, let me release all of you, but don't. Okay. I think the net is worrying. Yes, is the person who wants to speak, you can speak, and then we will end the class. Yeah, the one who wanted to speak.
Madam. Yeah, I wanted the time for Thursday evening and then the